What name would you be logged in under?
It should be under my name, Kelly Ayers.
Yeah, it's not showing up, ma'am. Well, that's all right. You can participate by phone. All right. So, Mr. White, is this your motion?
It is indeed, Your Honor. Did you receive the answer filed by the defendant?
I did. Hold on. I did have something. Yes, I do have that. It was handed to me this morning. So yes, I have that.
Okay, Your Honor, I've reviewed the answer, and unfortunately, the defendant attaches a copy of a number of text messages, but I'm deeply, deeply concerned that the defendant failed to attach the important parts that occurred prior to the attachments he did. He completely ignores, I have 40 pages of messages, and Your Honor, just to make this really clear, the defendant is saying that nothing bad is going on. Apparently, this is just some type of grudge that my client holds. On Sunday, August 2nd, 2020,
the opening moments reveal a dispute that is really about credibility, not custody. Before anyone debates legal standards, both sides start fighting over which facts deserve the court's attention. That matters because family court rarely reacts to isolated events.
The defendant sent a text to my client. Do not speak to Jasmine. Kim's best interest is not in her mind. He also followed that up with, right now, until she leaves, Jasmine is far from suitable for our daughter. There's a long series of messages where my client's bringing up different things, and the defendant's actually admitting. In fact, he says again further in that conversation, if Jasmine sticks around too long, I'm drinking the bath water. I have 40 pages I'm happy to submit to the court. My client is going through over and over trying to make sure that this minor child is safe from apparently Mr. Silvius's girlfriend. That's very, very concerning. My client took some action once she received notice from Mr. Silvius that his current girlfriend or whatever was a danger to the child. She was happy that he was taking care of it. And then what happened was he went back to her. And my client took action to protect the minor child. Could you imagine being a parent, having the other parent saying, hey, don't speak to Jasmine. It's not suitable with Jasmine here. And then he goes, everything's going to be okay. Clearly, that's a big issue. They also make an issue in their answer. They spend a lot of time on a timeline relevant to a current issue. They attach a whole bunch of things from 2013, which, as the court knows, can't be considered. But if you're going to consider it, for some reason, the defendant didn't mention that he's a convicted felon because he had actually involved a firearm in this case. He pled no contest to, I think, 2 felonies. And there was an emergency order, and he was barred from having a handgun. Well, lo and behold, this weekend, this girlfriend of Mr. Silvius posts a picture on her Facebook. Man Crush Monday. I love this man. And it's a picture of Mr. Silvius holding a handgun. I don't know the date of it, but we should probably forward it to the prosecutor's office because I've seen them charge people for felon in possession of a firearm just simply on photographs like this. This woman, Mr. Silvius, has essentially chosen over his child, clearly meets the standard for proper cause or material change in circumstances. Bodvarka makes it quite clear. If something could have or have a significant effect on the child's life, clearly you've got a quasi-step parent that's a problem. Her child actually violently assaulted this minor child, which also is an issue. We've clearly made a showing of proof that there's been a material change in circumstances. My client remains deeply, deeply concerned about the safety for her child, given the messages from the defendant. We'd ask that you set this matter for an evidentiary hearing as soon as possible.
Thank you. Mr. Lojuri?
Yes, Your Honor. I'm going to back up a little bit, Your Honor. When these parties were divorced, they went through a very contentious divorce. It was actually after meetings in your chambers between counsel that these parties agreed on joint legal and joint physical custody. For the last 4.5 years, the parties have been exercising a different parenting time schedule that's in the order, week on, week off, Sunday to Sunday. They've been getting along very well, with mother having served as dad's buyer's agent for his new house. What happens on July 26th, Your Honor, the mother and her new husband are visiting my client and his girlfriend at his new house, and she's meeting the girlfriend for the first time. She alleges that during this time, my client's girlfriend's 5-year-old son, Cooper, hit the 8-year-old daughter of the parties in the back of the head. One of the text messages that I attached, but she doesn't tell, although they're all there.
The plaintiff's argument focuses on one theme that often carries significant weight in custody disputes: parental judgment. Rather than claiming a child has already suffered lasting harm, the presentation suggests that the father's own words demonstrate he recognized a potential danger before later reversing course.
At the same time, she doesn't tell dad about it until a week later. I agree with Mr. White. I'm not going to dispute that my client sent text messages to the effect that Mr. White has indicated. And what he's been doing and what they've been doing for the last 4.5 years is they've actually been getting along and communicating openly and freely. And we haven't been in court in a long time after being in court a lot during the divorce and shortly thereafter from the divorce. What she does is she goes to the court and she asks for an ex parte order to suspend his parenting time. The court denies it, and my client hasn't seen his daughter in the last month. And what's happened in the last month is my client has resolved his issues with his girlfriend. They have procedures in place that they're gonna, Kim, the child, is not in danger. There was this one incident where a 5-year-old hit the child. I don't think that's clear and convincing evidence that a 5-year-old and an 8-year-old, that the child's endangered mental, physical, or emotional health is in danger. Yes, my client expressed those concerns to the plaintiff regarding what his current girlfriend, but those issues have been resolved, Your Honor. I should also point out, because I should make this clear because I don't want to have any issues in the future, the felony that he's referring to, that was known during the divorce, and that was all known when the parties agreed to joint legal and joint physical custody. I should also indicate on the record that Mr. Fallahy represented Mr. Silvius in that felony. We're waiving any conflict that may or may not exist regarding that issue. I'm not saying that there is one, but Mr. White's office did represent him on that felony. It was always a known thing when we decided this, Your Honor. So here's what happened, though. So my client, who has his daughter's best interest in the forefront of his mind, openly, frankly, and honestly communicates with his ex-wife, the mother in this case, about his concerns, saying he's going to address those concerns. That's why I attached those text messages. That's what we would hope in any post-divorce situation, that people communicate and that they co-parent. He's being honest, he's addressing it. Instead of mom working with him, she files her own ex parte motion with this court seeking to change custody. I say, Your Honor, that we can set this for an evidentiary hearing if the court likes, but in the meantime, I would like that my client's parenting time, that the child be returned to him for his parenting time, and that he receive makeup parenting time. Does the court have any questions of me, Your Honor?
I do not.
Your Honor?
So, go ahead, Mr. White.
Well, there is an audio tape also, Your Honor. unfortunately, the defendant makes it sound like my client ran in to get an ex parte order. Not only did he fail to inform the court about all the text messages where he's expressing concern for the minor child because of his new girlfriend, he also admits the assault that the new girlfriend's child committed. He admits to it in the text messages again, weren't provided to you. They're talking about resolving the issues. Resolving what issues? You have a new girlfriend. You send your former wife messages that basically don't let our child around her, and I'm concerned. But now he's resolved it. Resolved it how? He's obviously picking his new girlfriend over his child. If you're going to have parenting time, Your Honor, this isn't his wife. She's fairly new. The stuff she posts on Facebook is beyond racist and disgusting. She doesn't need to be around this child. We've clearly met our Bodvarka standard. If the parenting time is going to occur, this girlfriend can't be around. I'd be happy to supplement the court pages of crazy stuff from Facebook, not only posting a picture of Mr. Silvius holding a handgun, but some just incredibly racist, inappropriate stuff.
The defense takes a very different approach by emphasizing stability instead of conflict. Rather than denying difficult conversations happened, counsel openly acknowledges them and reframes those messages as responsible co-parent communication. That is a strategic move because admitting limited facts often appears more credible than rejecting everything outright.
All right, well, here's what I'm going to do. I want the parenting time resumed. I'm going to order that there be no unsupervised contact between dad's girlfriend and the minor child when the minor child is there. And I'm going to order an evidentiary hearing at which I will address initially whether or not the standard has been met. If I find the standard's been met, we'll proceed with a full hearing on best interest factors, et cetera. I also will be conducting an evidentiary hearing whether or not parenting time has been wrongfully withheld and consequences adherent to that if I make such a finding. I'll have Dawn find a date that works for both of you gentlemen.
I'll try to get an order to them here shortly, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you, Mr. White. Take care. With your permission, Your Honor, I'm going to leave the
Your
meeting.
Honor, I have a question.
Yes, it's hearing's done.
Thank you.
If everything is reinstated, how does our daughter's virtual schooling work out?
That's for the two of you to work out yourselves, ma'am. That's not in front of me today. Have a good day.
Oh, that's fine.
Thank you, Your Honor.
Okay, this is Ayers versus Silvius. Mr. White for the plaintiff, Mr. Liljuri for the defendant. And it appears that both parties are also present in their attorney's offices.
Good morning, Your Honor.
Okay.
Your Honor. Good morning, Eric.
Good morning. All right, Mr. White.
Thank you, Your Honor. I know the court's read my motion. It's rather bizarre, and unfortunately I need to update the court. It gets worse. The defendant's friend she did make a false report to CPS. CPS came to my client's home. They did a quick investigation and found that it was a false report. This young lady also contacted my client's employer and made a complaint that I have copies of indicating that she had been racially discriminated against in the sale of a piece of property. Interestingly enough, this Jasmine McJames is a white person, so it appears as though she's wreaking havoc on this family, and we need to protect the child from what's going on over there.
Okay, Mr. Liljuraj, I don't know if you filed any kind of
No, Your Honor.
response.
No,
I'm not surprised because I know it was short notice, but
I have
I really I don't know the defendant's position on any of these allegations.
let me, it won't be long, what I have to say, Your Honor. This all started, my client told this woman, Jasmine, that's her first name, that she needed to move out. In response to that, she retaliated and sent these messages that my client drinks and drives with the child in the car. That's not true. One of the things that is true, because I want to be honest with the court, is he did say to her, they put in their motion, Mitchell did say to Jasmine, you know, why don't you just start a shotgun? He admits to saying that the child was not there.
The second hearing dramatically changes the tone because the conflict expands beyond disagreements between parents. The alleged behavior of the girlfriend becomes the dominant issue, with claims involving CPS reports, employer complaints, retaliation, and increasingly disruptive conduct. Interestingly, the defense does not spend time attacking these allegations.
This all started because he said she had to move out of his house. She is in the process of moving, is going to be completely out by tomorrow. Correct, Mitchell?
Correct.
And then so she sends these things like trying to make Mitchell look bad. Then she sends these disgusting text messages to Miss Ayers, just disgusting messages saying, I didn't mean that, I was mad, and says all these horrible things to her. Threatens to call CPS. My client does not have any concern about Miss Ayers' husband, so he didn't want that to happen. My suggestion, if I could have any, is that I think Miss Ayers needs to get a PPO against this woman because what she's doing is wreaking havoc, not just in Mr. Silvius's life, but also in Miss Ayers' life. And I'm sorry that happened. Obviously, this Jasmine is not a healthy person, and that's why Mitch is terminating that relationship and told her to move out. And as a result of that, all this happened, Your Honor. So I don't dispute anything Mr. White is saying. I'm just giving the court the context. And what I'm asking the court is the parenting time be restored, that I'm okay with the condition that this woman never be around the child. You know, she's gonna, like I said, she'll be out of the house tomorrow. She signed a lease in Lansing. Anything I'm saying incorrect, Mitch? Okay. So I know this woman is an unhealthy person.
It would appear that way from
Yeah.
everything that I read.
It's disgusting, you know?
The problem, Your Honor, is just as of yesterday, Jasmine, who's from Ingham County and supposedly is moving up there, was on Facebook in a group looking for a daycare in Napoleon. This was just yesterday. My client remains strongly concerned that this breakup between Jasmine and the defendants is not going to actually happen, and that we're going to be back in the same boat here shortly. As you could tell from the previous motion that my client had filed that has us waiting for an evidentiary hearing, this is unfortunately part of a continuing pattern. And I don't know if it's how I could do this, but perhaps the court should hear the defendants being audio taped by Jasmine. It's kind of disturbing. I'm just not sure how you can protect this child when it doesn't appear that Jasmine realizes that this relationship's over.
Well, my suggestion is, and I would consent to it is that, my client would, is that a condition of restoring parenting time is that this woman be nowhere near this child. If my client has to get a PPO against her for that to happen, um, I'm in a strange circumstance, Your Honor, where I agree with all their concerns. But I think it's remedied by she's moving out and that she shouldn't be anywhere around this child. And Miss Ayers can do what she wants, but she may want to consider getting a PPO. And that's something eventually my client might have to consider.
The plaintiff repeatedly argues that temporary distance offers little protection if the relationship later resumes without warning. Meanwhile, the defense accepts strict conditions and even suggests additional legal protections against the girlfriend. This rare alignment allows the judge to move away from determining who is right and instead focus on creating practical safeguards that can immediately reduce future risk to the child.
So, if I were to restore parenting time with an absolute condition that there be zero contact and zero exposure of the child to this woman, why doesn't that at least solve this immediate problem, Mr. White?
It certainly does. That certainly does. But it's funny. I love social media. 25 minutes ago, Jasmine is posting her status that now she's in a complicated relationship. I guess my client can certainly live with that. And we're going to have an evidentiary hearing coming up. But I think we need a mechanism in which where we can come back before this court if it turns out that Jasmine is still in the defendant's life. I'm not sure exactly how we could craft something, but we've got to make sure that if she comes back in his life, we've got to have some protection for this young girl.
It looks to me that the defendant has complete control over that.
Yes.
He cannot allow her back. He cannot allow this child to be exposed to that woman ever again, ever. And if that happens, if my order is violated, I will be left with sincere reservations whether I can ever trust Mr. Silvius again to protect his child.
Your Honor,
The consequence would be very, very serious. This woman is unstable. I don't want her around this child ever. If you need to get a PPO, get one. But she's got to be gone, and there cannot be any exposure. So I'm going to restore the parenting time with that absolute condition that there be no exposure and no contact whatsoever with between the child and Jasmine, whatever her last name is.
James.
McJames.
I'll prepare an order, Your Honor, and I know my client feels better hearing you clarify that this person's got to be out of the child's life for sure. So we appreciate that. I'll get an order prepared and appreciate the court's time.
thank you, Your Honor. Thank you,
Okay.
Mr. White.
Thanks, Nick.
you, and we'll.
Have a good day. Thank you.
The judge's questioning exposes the real issue beneath every allegation: control. Instead of becoming absorbed in social media posts or personal disputes, the court asks whether the father has the ability to completely prevent future exposure. That question transforms the case from one about another adult's instability into one about a parent's willingness to enforce boundaries. Once the father is described as having complete control over access to the child, responsibility becomes unmistakably personal. Any future contact would no longer appear accidental or unavoidable. It would reflect a conscious parenting decision. This reasoning gives the court a clear enforcement standard while avoiding unnecessary complexity. The message is simple. Protection of the child depends less on predicting Jasmine's behavior than on expecting the father to make disciplined choices. The hearing concludes with consequences that extend well beyond the written order. Parenting time is restored, but the judge deliberately attaches an unmistakable warning that future compliance will determine the court's confidence going forward. Trust becomes the central currency of the case. The father receives another opportunity to demonstrate sound judgment, yet the margin for error is dramatically reduced. By emphasizing that any future violation would create serious doubts about his ability to protect his daughter, the court establishes expectations before another dispute can arise. That approach serves both legal and practical purposes. It restores the child's relationship with her father while placing full responsibility for maintaining that privilege squarely on his future decisions. From this point forward, conduct will matter far more than promises.